The problem of having a long contract is as difficult as having a short one. A couple of months ago, this client came to me who told me that he is a broker for some rental services where he finds a renter for the owner of a premises and he takes a little bit of commission for providing that service. Now, to do that, he used to make the landlord of the premises sign a simple brokerage form, which ideally should also be sufficient. But after the premises was taken up in one situation, the owner of the premises refused to pay the commission of the deal to the client of mine. Of course, we pursued our remedies in law against that landlord. But the client asked me if I can prepare a more detailed brokerage agreement, which if the client presents it to somebody else and if they sign it, they'll feel a much more bigger responsibility to pay that money. I prepared that brokerage agreement for the client and gave it to him. Just last week, the client called up again and said that there have been situations where landlords have refused to sign this brokerage agreement only because it is too lengthy and the landlord does not understand the agreement. The landlord says the industry standard is a one-page brokerage agreement. And I made the client understand that he can also use that one-page brokerage agreement with that much effectiveness. But there are always these situations which are not really covered under a one-page agreement. And if those situations are not there, it leaves the matter to more ambiguity and more disputes will arise, and there will be a lesser chance for you to recover your money, which you have a right to recover. And that is why uh, you should always have to kind of, balance out the requirements of having a long contract with the need of the other party, that the other party should not back away from signing of that contract. One way that I explained the client was that you should explain to the person that this is something which is very, very necessary. And if you have any doubts, any apprehensions about going through with this deal just because of the length of the document, you should yourself engage a lawyer, find out. You tell the opposite party, find a lawyer for yourself and confirm whether what we are talking about is correct or not. And this also kind of leads me to talk about this one thing that a friend of mine asked me just last night about what kind of responsibility do people have when they are entering into contracts? Do people understand what kind of contracts they are getting into? And my response was that I have seen both kinds of people. I've seen people who are so good with contracts, who are good with dealing with people, that they do not really need a lawyer to draft contracts for them, right? They are able to understand that, okay, these are the 5 requirements that I have in my contract with the other person, and he will spell those terms down. But I have met an equal number of people who don't really understand how these contracts work, and a lot of it is also pertaining to the law of the land. So in India, if you write certain contractual terms, a lot of times you will find that those terms cannot be enforced because the Contract Act of India says that they cannot be enforced, or they'll be enforced in a different way according to what the Contract Act says. And because of that, we kind of have to be a little careful. At the end of the day, I think it boils down to this simple question: what are the implications of that contract? If it's a substantial contract, you might face any problems in the future. It's better to get a lawyer to look over the terms of the contract. If it's a simple document and it doesn't require much thought, you can very well go ahead, draft the contract on your own terms. I'll maybe make a video in the future about what kind of terms you should have, especially in the more common forms of contracts such as sale and purchase, rent agreements, and other similar kind of contracts.